Start your
Am I audible,
suggestions.
ma'am? Am I audible?
Yeah, you're audible. Yeah.
Yeah. Okay. So good afternoon, everyone. This is Jaydeep Indoria with Sonalika Nigam. Keeping the time in the mind, I would directly shoot up with the suggestions. So the first suggestion which our law school would like to keep front is we all know that law is a tool and justice is an abstract. And to ensure justice is done, courts in India are familiar with the constitutional mandated and statutorily recognized principle of open courts. However, the principles of public access to records must be balanced with the concerns of breach of privacy owing to the vast amounts of personally identifiable information processed by the courts across the India. But further, the digitalization of the court records, while increasing accessibility and efficiency of the courts, raises the concern of misuse or event of such personal information being might be wrongly accessed or disclosed. So the suggestion would be we could come with a judicial information management policy where we just set out a framework for access based on the various types of stakeholders within the judiciary, with demarcation on what kind of information will be accessed by each set of stakeholders. Maybe the the people within the judiciary or the general public, maybe what kind of data can be accessed by the researchers, scholars, and what can be accessed by the people who are within the judiciary. The second suggestion, which I would like to quickly mention, is we know that legal aid is not a work of charity. We should consider it as an obligation of the state and the right of the citizen. Thus, it is obligatory on the part of the judiciary to introduce appropriate reforms to improve delivery of legal services to one and all. Basically, if we talk about the quality of legal services, we know that it depends upon the quality of lawyers we engage. And for this purpose, a good lawyer has to be reasonably compensated. And as said, it's not only a responsibility of one stakeholder, but of all the stakeholders of the judiciary to make legal aid available. For that purpose, private law firms, non-governmental organizations, civil society organizations, the new concept of think tanks, we can say, can be partnered to provide pro bono legal aid services to the marginalized. The participation of voluntary organizations and social action groups, as we know that there are some schemes where these all are supported, but there should be a legit encouragement given to these voluntary organizations in order to really achieve the objective of Article 39A, which is clearly enshrined in our constitution, which is, we say, that the most deliberated and negotiated document of the world. The bridging gap, which we have also studied in the gap analysis, the bridging gap between the justice and the sufferers is the need of the hour. The other reason for the inclusion of such groups, what I believe, is that judiciary of any country should be an integral part of the society, which we already discussed, and its interactions with the society must be regular and relevant. It is also seen, many of us know that there is involvement of common citizens in the judicial decision making in several countries, and this can be one step towards it. And now I would like to Sonalika to please continue with the other suggestion.
Thank you so much, Jerry, for the opportunity. Though the following points are incremental in nature, but we believe that they are the basic steps which we need to ensure in order to promote the citizen-centric justice system for our country, India. The third suggestion goes like that: there should be an increase in the number of judges in all the courts across the country. Honorable authorities, the statistics are in front of you all. There are approximately 21 judges per million population, which is very low, and this gap needs to be fulfilled at a very wide stage. The fulfilling of the gap would ensure that we are utilizing Article 39A of our Indian Constitution with the help of pro bono legal services. At the same time, the introduction of the All India Judicial Service Examinations, that is AIJS, can be of great help. It will ensure the adequacy of courts and judges by the inclusion of qualified, fresh, legal, talented, and selected candidates through a proper All India merit selection system, as well as envisage the citizen-centric approach of our Honorable Prime Minister. Now, the fourth suggestion is the establishment of a training system whereby the people having their place of employment in the courts, that is to say, the judges, the advocates, the munshis, the clerks, the peons, and everyone else as their employment in the court premises, should be trained and given the training regarding how to efficiently and patiently deal with the people approaching them, just in the similar manner as the doctors are trained. No doubt this might be happening at a very large scale in India currently, but while interning in the district court for 1 year, for 1 month, I came across this problem that people are not expressively able to talk to the people who are sitting there. There is a communication gap which we need to fill up in order to promote justice for all. Believe me, this has an absolute connection in the improvement of our judicial system. This suggestion is inclusive of the fact that if this is brought in force, it could also strike down the corruption rate in our judicial system. At the end, I would like to say that in 2047, the year when India will celebrate its golden year of independence, then at that juncture, the world's largest democracy should have the best judicial system at its end. Thank you.